Hey everybody, and happy Monday. Thank you for getting back with us. I hope everybody is going through this heat okay. It is certainly some record breakers, and July is always like that, and you know, in terms of court, we've been really busy. We always talk about, and we've covered it quite a bit and had a ton of discussions on our Facebook page back and forth about how much time a person got and if that's too much time or too little time. There's a lot that goes into that. We've covered that ad nauseum, but one of the main things to keep in mind is that our part is being prosecutors. We bring the case, we put the case on, we put up the witnesses to prove our case. On the other side is the defense, and they try to knock holes in that story, or to say, you know, more should have been done. And ultimately, on trials, there's no sort of plea agreement or anything like that that everybody has a hard time with. That is whatever the judge gives, the judge gives. Now, generally, at the end of a trial, a person's going to get more time than they would if they were to have accepted responsibility early. Now, we're just one state out of 50 states, but every state does the exact same thing. And more especially for our area, that number I give you all of the time, it's 10,000 warrants in Horry, about 2,000 in Georgetown. That's 12,000 warrants. There are 52 weeks in a year that we can't do one thing about. Can't make more time. So we have got to somehow move 10,000 warrants in 52 weeks. Like this past week in July, both of these trial rosters, we had multiple judges doing trials and we had multiple judges doing pleas. So we got one judge to do a murder trial, which took, it was a armed robbery, and then we came back with a drug trial. We tried two in this week in front of this judge, and then in front of the other judge we had several that were on here that ended up pleading guilty, and we talked about those. The murder case out of Green Sea. But what you see is like the lady that pled at the last minute, even though it was still a plea, there was absolutely no plea offer for her. It was 30 years is the minimum, maximum is life imprisonment, and the judge heard the facts at a plea and gave her 40 years, I think it was, and gave the son 35 years. Maybe it was 45 and 35. But that is, they didn't get as much of a break, but there was no sort of plea offer there. For the son, there was a plea offer, and that was, Judge, would you cap his sentence at 40 years, not give him over 40? Judge gave him 35. A lot of that had to do with his age. Now, I love the fact that you'll come in and comment on it. I think our main goal here is to be transparent. We want to show you exactly what happened and go ahead and give you the rest of it. When the Supreme Court has said that even though you waive a juvenile up as an adult, there's still got to be a hearing and factors to consider. You can't just give life imprisonment, or that's going to come back. And for about 5 years, we've had to go back and justify every one of those sentences that may have been 20 and 30 years before, because the Supreme Court has said a juvenile should be treated differently, even though they're an adult, because they were waived up. They still have to be looked at as juveniles. So we did make a plea offer on his behalf to cap it at 40 years, and the judge, of course, gave him 35 years. a lot of these, like there was a ton of discussion on Mr. Chestnut and him getting 25 years for drugs, trafficking weight. It was either his second or third. There was, in that case, it was a trial. The judge couldn't have given him 26. The legislature wrote that law saying the sentence for trafficking third is 25 years. Not 26, not 24, there's no discretion. If he's found guilty, it's 25 years. That's why he got 25 years on drugs, but he had priors. And a prior record will go with you for the rest of your life. So in the case, which may have broken some sort of record, but we had a case that we tried, and his name was Chawanda Bryant. And we've talked about this on this, that Mr. Bryant had a prior most serious offense. In South Carolina, we've got a 3-strike rule, which means 2 priors, and then you get hit with a third. One of the most important things that you'll see in this, and this is the good part about having all of these together with the trials, is prior record. And if you have a most serious offense and you get hit with another most serious offense, the judge has no other alternative but to give you life imprisonment without the possibility of parole. There's a ton of discussion about, well, he only got $200. He didn't kill anybody. But he was never charged with murder. He was charged with armed robbery, use of a weapon to take something of value from someone. And he would never have gotten life. He couldn't have gotten life if that would have been his first offense. But he had a second offense. He had 2 most serious offenses. And as some of the commenters said, he was also charged in the interim with another murder. We won't go forward on that murder because he's got life imprisonment. And we talked with the family about that. So if you're a parent and you're talking to your kids, just like our parents talk to us, what goes on that record never comes off. There are limited, very few cases that you can get something expunged or erased. But for the most part, 99.9% of the stuff that goes on your record stays on your record. And for the most of the time, all that does is keep us from getting a better job because we've got a record. But you can see where it stacks on top of each other. And if you've got a most serious offense like armed robbery or manslaughter or murder, and you get another one, it's life imprisonment. That's all the judge can do at that point. Life without possibility of parole means you die in prison. So I know it generated a lot of discussion. It should have. I hope this helps clear up some of that. It really depends on your prior record. It really depends on what sort of stuff you've done in the past. There are times that a person with no prior record gets popped with life imprisonment without possibility of parole. But that is less common, and it's a for sure thing that if you've got a most serious and you get another most serious conviction, it's not just to be charged with it, but a conviction, that means you're going to serve the rest of your life in prison. And that may seem harsh, but that is what our laws dictate. And we have to serve a person with notice of intent to seek life. I make a big argument that under the statute, the only time you've got to legitimately serve them with notice of life is when you're going under the 3 strikes rule. But under 2 strikes rule, it says the judge must sentence. So it doesn't matter if we serve them. We do, just to take that argument away, we come in and serve them with notice saying we intend to seek life. But you don't even really have to serve them with notice if they've got a most serious prior offense and you hit them and try them on another most serious offense. So I hope that answers some of those questions that came about last week. We will be in court in Georgetown on a murder trial next week. And that'll start on Monday. It should be through by Wednesday or Thursday of next week. But I'll be back to report on the comings of Georgetown County. Then the following week we'll be back in Horry County, and that'll be another murder trial.